Hey guys, welcome to our first live feed. We're getting ready to learn how to do this. So tonight at 8 o'clock, we're going to have our first promotion about our online course, our new online course. We're also going to have a mini workshop and we're going to cover how to use the jurisdiction to get control of your foreclosure today. So welcome to Advocates for Justice Foreclosure Defense Paralegal Service. We are different and we prove it. So today we're going to talk just a little bit about, first off, I want you guys to make sure you subscribe to my channel, and that's going to help me be able to provide services for people at a much better cost. So you guys subscribe to my channel, and if you have any questions, just type them in the chat window there to your right or left, and I'll answer those questions for you. We're going to take a few minutes. We're kind of figuring out how to run this our live stream program here, so bear with us. We want to get this set up so that when we start our training tonight, we'll be ready to go and have an idea of what we're doing. So that's what we're doing here today. We're going to talk about how jurisdiction affects your foreclosure and how you can use that to get control of your foreclosure. And remember, Advocates for Justice Foreclosure Defense Paralegal Service, we are different and we prove it. So I'm looking forward to the stream tonight to review our online course. We're going to take you guys inside behind the scenes so you can get a look at what it looks like, what the curriculum of the course looks like, and then you'll be able to ask any questions. Once you do that, you'll be able to see the value that my new online course is going to have for everybody. And if the course is a little too much for your budget, we already have our website set up with our foreclosure defense lawsuit packages on it. So that would be an option for you. Hello, Frankie. How are you today? Do you have a question for me? Frankie just gave me some hands and said hello. So I'm saying hello to her. And we're going to give it a little time here in case anybody else wants to watch. Foreclosure Rescue, that's what we do. And we're very proud of it. So we've been helping people now for quite a while. We have a Facebook page. It's called Foreclosure Rescue. And I'll leave a link down below to that page. I'll also leave a link to our new online course, so you guys can get over there and check it out. So Frankie, you know what? Everybody says their foreclosure is complicated, and you know what? At the end, it's usually not that complicated because you never want to go into foreclosure court arguing the banking system. Okay, the only thing you want to argue is jurisdiction. That's it, and that's what we focus on. When you argue jurisdiction, it takes all of the steam out that the attorneys have because everything they're doing is fraudulent. Hey, Ken, nice to see you, buddy. Loud and clear from Northern California, 707. Yeah, Ken McGuire has been one of our fans for quite a while, and he's also provided some very good publications that we've used to help people out. Our online course, we're going to feature the resource. One of the main resources that we're featuring in the online course is the banker's secret manual. And you guys can thank Ken McGuire for that because he sent that in to us. And it has been very, very helpful in helping us take control of the situation. Now, if you guys, you'll get a free copy of the banker's secret manual when you enroll in the class. And if you would like a copy of it before you enroll, you can go to Hamilton Radio on the internet and they are offering a copy of it for $10. We're helping them raise money through the pandemic, and they're actually are setting up. We're talking now about maybe having my own show on their radio station. So that would be a great way for people to tune in every week on Wednesdays and check us out and ask any questions. So we haven't got everything lined out yet, but I will let you guys know when we get that lined out exactly what time that's going to be on Wednesday and what time zone it's going to be in. So that's something that we're looking forward to getting going here in the future. I'm hoping next week I can start. I did an interview this past Wednesday, and it worked out pretty well. And Gene over at Gene's the owner of the radio station. He's a great guy, and I'm really fortunate that they're giving me an opportunity to communicate with their 55 million listeners, so we can help people with this foreclosure situation, because it's only going to get worse. I had one of my clients from the Facebook page was telling me that she works in the bank, and she knows that even during the pandemic, everything was closed off to everybody except the attorneys. The attorneys were continuing to go into the bank and the title office doing all these things, and you know what they're doing? They're getting everything ready. So when it's all opened back up, they'll already have an opportunity to jump on people before they have a chance to get in court. And that's why it's so important right now to take action and not wait. A lot of people now, I get it. The pandemic started and everybody's worried about the financing and worried about if you're going to be able to eat next week. But you still got to worry about protecting your family and making sure that you get to stay in your house. So you got to make your moves before the end of the road, because what's going to happen is all of the people that have took the time to get things going right now are going to be in front of the line, and the other people are going to be in the back of the line waiting on an opportunity to get into court. And while you're waiting to get into court, they're going to be taking advantage of you. And that's what I see. So it's really important to make sure that you take advantage of these opportunities. And it's kind of interesting because even if they shut everything down, you can still get your paperwork in the court and jam them up. At the end of the day, the attorneys they're not going to be so concerned with messing with people who are costing them time and money, because they have all these other people over here that are just throwing in the towel and don't feel like they have any chance. And that's what we're here for, to make sure that you know that you have a chance. But you have to be willing to do whatever it takes. And what we're finding right now is the judges are helping these attorneys by trying to dismiss your stuff. And one of the things that I tell people is that you're going to find out that at the end of the day, it's not going to be about all the nuts and bolts of your foreclosure and all that. At the end of the day, it's going to be about the fight that you're going to have with the judge to block him from illegally dismissing your lawsuit. That's what it's going to be about. So Frankie's saying something to me here. Yeah, Frankie's calling from Texas, which is non-judicial. And no, Frankie, the foreclosure is not from the bank. The foreclosures are being done by third-party debt collectors. Okay, and that's my take on it. And the reason I believe that is because if you'll check the signature on the document that they use to start the foreclosure against your property, in your case, if you're in Texas, is non-judicial, it would be the notice of default. The notice of default letter is what is used to execute the power of sale clause in the deed of trust in a non-judicial foreclosure. And that letter is supposed to be signed by the trustee, but it never is. It's signed by the attorney. Now, what we teach people how to do is that person who signed to initiate the foreclosure against your property, that person should be the number one defendant on your lawsuit. And this is the biggest mistake that most people make. They don't even have the person who signed to initiate the foreclosure. They don't even have them on their lawsuit any place. And if you stop and think about it, once you add the attorney to your lawsuit as the number one defendant and their law firm as the second defendant, they have a problem. And this is the kind of things that we teach you in my non-conventional strategy. We teach you how to jam them up using their own stuff. And think about it. The attorney can't represent himself, and the attorney cannot litigate a case that they're a party to. And one more thing people don't understand. The attorney cannot represent the law firm he's affiliated with. It's considered pro se representation, and it's not allowed by the court. Yeah, so now the attorney has to hire somebody else. And that becomes a problem for them too. And I'll tell you why. In your lawsuit, you're going after the attorney for wrongful foreclosure, breach of contract. And you're claiming in this lawsuit that you get from me, you're claiming that the attorney is acting as a third-party debt collector. And you're claiming that because no one from the bank signed any of the paperwork. No one from the bank is anywhere to be found, and the attorney's name is the only name on the paperwork. And that's why you add the attorney as name one defendant. So you're claiming the attorney is attacking your property in foreclosure, illegally acting as a third-party debt collector. Now, once the other attorneys find that out, what do you think they're going to do? Right. They don't want nothing to do with it because they're doing the same crap. So now the attorneys are left with a dilemma. They either dismiss the case or get the judge to allow them to go and represent the law firm they're affiliated with and ignore the rule. That's usually what happens. And when that happens, in your package, you have a document called a demand to strike, and you're demanding to strike the attorney's notice of appearance because the attorney can't represent the corporation he's affiliated with. In court is considered pro se. And once you move to strike, all of the attorney's documents they file in court will be stricken from the record as well. And if the judge allows the attorney to go forward, now you can file your motion for reconsideration. You file a motion to recuse the judge, and then you file your notice of claim, and then you file your notice of appeal like the next day before they even have a chance to respond to it. Yeah, I like doing that. And now the judge has to decide, does he want the appellate court to see his dirty stuff, or does he want to allow you to pass the gate and get in court? And that's been working very well for us. Now, one of the things that people need to understand, is if you don't have the courage to hold the judge accountable, then you should not invest in my program. If you have fear or you're scared of being retaliated against for standing up for your rights, protect your family, then you shouldn't get in my program, okay? Because in my program, my documents are up in their face, and that's just the way I'm going to put it. And you can't decide you're going to do this, file somewhere, and then change your mind and go sit down, because they'll be pissed. Because you know how they are when you back them in the corner and expose their lies. Okay, you know how they are. So Ken McGuire says, I'm correct. Thank you, Ken. Edgar, I'm going to purchase your COVID special. So Ed, what are you purchasing? What special are you talking about? What's your situation that you're trying to take care of, Ed? Oh, that's all right, Frankie. Your information is good that it's there. I'll be able to read it later, and we can talk later and see if we can figure out a strategy that's going to help you when I have a chance to read everything. This is like my first live feed, so I'm trying to get everything, actually this is the second one. The first one I had trouble with, and my wife came in to let me know that it looked like crap while I was in the middle of trying to record. I'm like, honey, I'm trying to do this. But anyway, I'm learning, and it's kind of nice. You can sit back and laugh at yourself when you look silly. if you don't ever step up to the plate to take a shot at it, you're never going to be in a position to get it done. So I'm all right with that. So Ed, are you in judicial or non-judicial? Well, thank you, Frankie. I'm glad you're interested in the package. I have a video on my website. So I want to talk about that right now for a minute. So my YouTube channel, okay, it's a little bit confusing, and I just kind of figured that out. It's a little bit confusing. So when you guys go to my channel, the very first part of the title is what I have of the video title is what I have in order for my video to rank. Because I'm a small channel just getting started, I have to be able to fit my stuff in the top 5 or 6 so people can see it. So the very first part of the title is just put there to rank. Sometimes it'll say for North Carolina or something. What I do fits in any state. So don't be distracted by that. What you need to focus on is what's in the second part of the title. That's more about what the video is actually specifically about. And that'll give you a little bit of a hand when you're trying to figure out what you need to look at for your situation. Now, the other thing that you need to keep in mind on my YouTube channel is that there's video playlists. So the videos are separated in playlists. So for instance, I have a playlist for instructional videos, which have all the instructions for the lawsuit packages. I have a playlist for strategies and tips. I have a video playlist for tips for in court. So we have different playlists so that'll help you kind of get yourself where you need to be to look at what you need to be looking at. But you need to keep that in mind. The first half of the title is just what I put so the video will rank high enough so that you guys will be able to see it. The second part of the title is actually what the video is really about, figuratively speaking. So with that in mind, that gives you a little better idea when you go to the website, and you can look at the second half of the title and pick the videos that fit your situation. That's going to help you. Add your non-judicial. So the non-judicial package, when I first started doing these lawsuit packages, I went through, okay, so I've been through what you guys are facing, except I went through the judicial foreclosure. And when I started putting these packages together, I had to go back to the learning page and do more research, because the people that were using the non-judicial foreclosure package was filing everything and getting everything done, but the federal court was stalling and the state court was picking up the pace trying to get people kicked out during the eviction process. So we had to go back and figure some things out. And what we figured out, and this is like one of the most important things that most people do not know that are facing eviction and a non-judicial foreclosure. So eviction court only has jurisdiction to make a determination on immediate possession, okay? They do not have jurisdiction to make a determination on the title dispute. So once I figured that out, the game plan was on. So your wrongful foreclosure lawsuit that you file in federal court, that is your title dispute. Once you get that title dispute filed, you can use that title dispute to control the whole rest of the situation. And I mean totally control it. And if they've served the unlawful detainer on you and you're in eviction court, all you have to do, now keep in mind, my non-judicial foreclosure package has like 16 documents in it. And those documents that we put in that package were added to the package after receiving feedback from members in our Facebook group who are using the documents in court. So we have members from, like you just said, from Texas, California, New York, Oregon, all over. And those members communicate with me through our private Facebook page. And I am able to figure out what I need to add to the documents to screw those doors shut that the attorneys are using when I get the feedback from people. And that's how the document ended up with, the package ended up with 16 documents in it. So you have documents in there. What the strategy for the eviction process is, once the eviction process starts, then, and you have your lawsuit filed in federal court, then you file your motion to challenge eviction court jurisdiction, and don't wait for the eviction court judge to answer to it. Okay, that's not what this is about. You file that challenging eviction court jurisdiction because you have a title dispute filed on the record in a higher court. Okay, once you do that, eviction court don't have jurisdiction, but they're not used to anybody slapping them in the face and taking charge. So we put a document in their notice of removal, and that notice of removal document you can use to remove the case from eviction court and connect it with your court, with your federal title dispute. And basically what you do is you file your notice of challenge to jurisdiction of eviction court, and you take a file stamp copy of that and you attach to your notice of removal. And the notice of removal and that attachment that you filed in state court, you file in federal court. And you ask them to connect it with your title dispute, because, and this is important, because the title dispute cannot be the immediate possession cannot be determined until the title dispute's been settled. And the title dispute's in the higher court. And so the lower court has to sit down. Now, in our new online course, we're going to be featuring brand new documents. And the new documents that we're going to be featuring in the online course are documents that some of our members in our Facebook page are using. The first document that you'll be using in our new online course is called the Jurisdictional Challenge with an Affidavit. And so far, I think in our private Facebook page, I have 4 or maybe 6 people that used it, and their foreclosures were stopped, continued, or the judge didn't rule and say, hey, you get everything, because that's never going to happen. But the attorneys were not able to respond. And to be honest, I have a couple of cases that used the jurisdictional challenge, but these two cases, the members forgot to remove it and allow the judge to rule on it. And the judge dismissed it and said he had jurisdiction, which is totally crazy. And when that happens, if that happens, I would immediately file my notice of claim, because the jurisdictional challenge with an affidavit has to be responded to by counter affidavit, or it's crap. And that's the end of that. The attorneys cannot respond by counter affidavit to this jurisdictional challenge. And we addressed some things in that challenge that came out of that PDF, the Banker Secret Manual, and that pretty much sealed the deal. So that PDF is very powerful, and most people, so the people who have invested in my lawsuit packages should have gotten a copy. And if you didn't and you invested, let me know and send me a private message, and I'll on the Facebook page, and I'll send it over to you. That PDF is something that you guys should review. Now remember, when you're reviewing it, it talks a lot about going after the bank and all that. We're not interested in that. We're only interested in the stuff that shows the bank's fraud and the things that they show in there that the bank does not want to talk about. And a lot of those things get cases dismissed because of the fact the bank doesn't want to talk about it. Now, one of the other things that we use in our brand new online course is the fact that the foreclosure statute does not have the necessary elements to be considered a valid law. And I've done the homework on this, and I've actually been challenged a few times. And yeah, they needed to bring a lunch and they went home hungry, because my homework is accurate. So let me see here what. Oh, thank you, Frankie. Have you purchased it today? What I used to suggest when you guys invest in a lawsuit package, I used to suggest you sit down and review the actual lawsuit document and the restraining order, and highlight any areas that you have questions on the computer. And then we'll set up a time where I can get on the phone and we can go over those highlighted questions to make sure you understand everything. And please, that's the way I have to do it. Okay, I don't have the patience to go over every single page with you. So it's going to work out a lot better if you highlight the areas you have a question on, and then I can answer those questions for you specifically. And that is going to be a more efficient use of both of our times. And so you guys have to remember, I have a lot of, sometimes I have a lot of calls to make. And so I might be a little bit short with you. Don't take it personal. And here's another thing. I had a lady get grumpy with me one day because I didn't have time to talk with her. Well, I actually had to cut her off and call her back, which I rarely do. But at the time, I had a client that was actually in court trying to get her stuff filed in state court, and they were giving her a hard time. And so she went outside the office and like texted me to see if I could talk. And of course, I needed to talk with her until I was, she needed to go back in there and tell them so they can get out of her face and file her stuff. And basically, and this is a good point that I need to cover too while I'm here. Whenever they refuse to file your stuff, what you need to do is you need to ask the clerk if, actually I'd ask for the supervisor, and then I'd ask the clerk's supervisor if he or she has authority to make a legal determination on your pleading, because only the judge has authority to do that. And the judge, if the judge don't like it, the judge should kick it out with his conclusions of law and facts of finding, which they hardly ever do. At least if the judge dismisses it, he should at least tell you what the problem is or why it's dismissed, if it's dismissed with prejudice or without prejudice, and give you a chance to go back in and take care of it. But here's the thing. If the judge dismisses your stuff, you're going to have to address it, because until you address it and hold them accountable, they're going to keep throwing you under the bus. And I have some people that are scared to do that. And that's why I tell people in the beginning, this is where it's going to come down to. So if you don't have the courage to do that, you probably should not be in my group. Hey, Tony George, nice to see you here. Yes, and Tony is one of our, she says the forms, use the forms, they work. Thank you, Tony. Thank you for that compliment. And yeah, they do. Yeah, Frankie, attorneys. So here's, Frankie, I'm going to explain to you why attorneys don't help people, okay? I'm going to explain that to you. The reason attorneys don't help people is because the attorney is the one that's stealing your property. Remember, we talked about in the beginning of this feed, the attorneys are the only signature on the document to initiate the foreclosure against your property. That's it. There ain't nobody else. And so the other attorneys are not going to challenge this attorney and jam him up, because that attorney is totally out of line and acting illegally. So any other attorney is not going to go against them. All they do is they keep their hand in your bank account until you run out of money. In the conventional foreclosure defense program, you have three options. You got your loan modification, your short sale, and your bankruptcy. And well, short sale, we ain't even going to go there. The bankruptcy helps some people, but most of the time you end up walking out of there paying more than you were paying in the first place. And loan modification is used nowadays to disqualify homeowners, because once you expose yourself and show them your financial information, they find out that you have more income going out than you have coming in, and they refuse to work with you. And then they start stalling. You need to send me some more paperwork. We lost this, over and over and over, until you get the thing in the mail saying your house is going to sell in 10 days or 15 days or something. So don't waste your time with the loan modification. That's my opinion. If you're going to do a loan modification, you need to go ahead and start your foreclosure process and get your stuff going. So in the end, when they throw you under the bus, you'll be sitting in a better position than you would be just taking that first step on the program with a short number of days to actually get it filed. Tony George says attorneys don't want to go after each other, and that's true. Frankie says she don't owe any money. So I have several people in the group Thank you, Alexander Neighbors. And that's my hero son there, in case you guys figure out our names are the same. And he's very good at taking care of business in a legal situation too. And he has several attorneys that are grumpy with him. I think they say something like the apple don't fall too far from the tree. A lot of times foreclosures are started against people who are not in default. And let me explain to you how that works. Yes, Ed, the foreclosure special that I have, the coronavirus special now, I know what you're referring to will work. If you're in Texas, you'll need the non-judicial package. Yes, it will work for you perfectly. So the coronavirus package. So before this coronavirus started, I had my lawsuit packages at $1,700, and I was trying to figure out why I didn't only sold a few of them. And then I read an article that actually opened my eyes. And that article said 80% of Americans can't afford attorneys. And I think that same percentage don't trust attorneys. And at the time, it said 52% of Americans live just like one emergency away from struggling. Yeah, well, we know that's much higher now with all the crap that we've been going through. So when this coronavirus started, what I did was I dropped my prices from $850, which was half price of what I already moved them down to half price. I dropped it down to $500 because I've been through what you're going through. And I know what it feels like when you can't protect your family. I know what that feels like. And I decided I'm never gonna have to feel that again. If I ever have to face foreclosure, I want to make sure I know how to take care of business and get it handled. What you learn with me is what I would do if my family was facing this problem again. End of the story. So I have people in the group that are not in default, not behind on payments, but they're facing foreclosure. And the first time I learned about this, it was with Jay and Sue Boyer, and they actually left me Google reviews. And I started helping them back, I don't know, maybe October of last year. And that was before Christmas because they were really freaked out that they were going to get kicked out of their property and spend Christmas on the street. And yeah, I'm proud to say they're still in their property. And the attorneys were not able to answer to the last jurisdictional challenge. One judge retired, so they're still in their property and they're still fighting. So that's pretty cool. So what happened with them, and I actually learned this stuff dealing with a couple of people that were facing a tax lien foreclosure. So the tax situation is what causes a lot of problems. People don't realize that. So what they do when you buy a property, the real estate deed laws mandate that the deed is supposed to be mailed to you, and it's supposed to be delivered to you. And so the attorneys do what they call their constructive delivery, where they trick you into allowing them to register it in their office. Now, here's the deal with that. There's no law in any of the states that I've been able to come up with that force homeowners to put their deed in the county recorder's office. There's no law. So basically, once your deed ends up in their office, now they can charge you property tax, the zone and code enforcement and all that. But let me tell you something else. That deed being registered in their office gives the bank's attorneys opportunity to put the mortgage lien against your property. Yeah, think about it. Your property was paid for in full when you signed that promissory note and they stamped paid to the order of on it and processed it through the Federal Reserve. That person's name that signed and that stamp to pay to the order of without recourse, that's the person that received the alleged electronic credits that they're claiming is the loan. So that's the problem. And people don't realize back in the day, back in the day, people's promissory notes, their contract, that stuff was kept in the Bible. There was no need to put it in some office where the attorneys had control of it. And ever since the attorneys tricked us into putting it in their office, they've been doing all this shady stuff. So the people that are facing foreclosure who are not behind on their payments, they're facing foreclosure because the attorneys went to the county recorder's office where their property is registered and got their property information and put it on a fake assignment and filed it in court as a foreclosure. And they know that 80% of us can't afford an attorney, and there's not very many people like me who are, have a YouTube web channel set up and it's giving people free information. There's not very many people helping people at an affordable price, and the help is actually making a difference. Not very many people. So attorneys know that. They got the odds going in their favor. And this is the same thing that happened to Jay and Sue Boyer. Their property got attacked by an attorney with a fraudulent assignment and dragged them into foreclosure. And luckily they found my service a little like a week or so before they were going to be evicted. And we're able to kind of throw a wrench in that. And it's been touch and go for a little while, but they finally got it under control. So they're still in their house. And I have another lady named B Brunning. She actually is also in Texas, and she invested in the program. She filed her lawsuit, but she didn't serve everybody. Now, B had mentioned to me in the beginning that she wanted to, her husband got a really good job and they wanted to just pay everything and be done with it. So I told her, if you do that, you need to make sure that the attorney provides you with a new contract. Otherwise, they will take your money and continue the foreclosure, and they'll be claiming you owed them the money from past payments. Well, she forgot to do that when she sat down with the attorney and worked it out. And the attorney that was foreclosing on her took her payment and went and sat down. And another attorney took over and foreclosed on her. And she did not even know that the attorney was following through or that her house was sold at auction until months later when the crew showed up to change the locks on her house. And yeah, that was touch and go. The fact that she had already filed her lawsuit stopped them. And all she had to do at that point was just serve everybody and go forward. And that's what she's doing. Now, I started helping her before Jay and Sue Boyer. And so that would have been in September of last year, I think, or something. And she's still in her house too. So we have people that are still in their homes, and they've been fighting for a year or so. And I have people that are in our Facebook group that have actually blocked the eviction sale. Shamel Maxwell, she blocked the sale of her dad's property and reopened the foreclosure in state court. And she filed her lawsuit in federal court and just moved everything over there. Yeah, and state court could not do a stinking thing about it. I love my job. No, Tony George, it doesn't matter if you're in default. You have now, okay, so you need to understand, there's, in each of the lawsuit package, there's a jurisdictional challenge, okay? There's a jurisdiction challenge. The jurisdictional challenge with an affidavit is a new document. And when you refer to that document, you have to use the full name so that I'll know that's what you're talking about, or I'll have to stop and ask you because they are totally different. Now, Tony, it don't matter if you're in default. you file that jurisdictional challenge in their face, and you stick only to argue what's on that paper. You're only talking, there's 6 things that you're claiming are missing from the original contract that's not on the contract they filed in court. Those 6 things are I don't know how you say that, the way that that whole transaction should have went, and it didn't go that way. And the other thing is you're going to be challenging the fact that the foreclosure statute that they're using does not have the elements necessary to make it a valid law. Those are the only things you want to talk about, okay? If you start talking about all that other stuff and all that other stuff, then you're done, okay? You just want to stick to the jurisdictional stuff that they don't want to talk about. So, Frankie, the reason the court don't have jurisdiction is because of the shady way that the paperwork is filed in the court. And tonight at 8 o'clock, I'm going to do a little mini workshop. We're going to talk about our online course more in depth, and we're going to do a little mini workshop, and we're going to talk about the different reasons why the court does not have jurisdiction. Well, you know what? I'm going to just show you a little bit right now, maybe. Now I'll have to figure out how to do a screen share on here. I'll have to figure that out before 8 o'clock. Well, we're not going to show you because I'm not sure how to do the screen share. I'll have to figure that out. So, Frankie, who has jurisdiction? The court don't have jurisdiction to hear their lawsuit against you because of the fraud involved. The lawsuit was initiated by the attorney acting as a third-party debt collector. That's pretty much it. Yes, Ed. All mortgage companies have been paid. Well, they get paid when they get your product. So what they do is they get your paper, they get your paperwork, they claim it on the insurance, this alleged loss, they get your loan documents or whatever, they claim it on the insurance as an alleged loss, and they claim it on their taxes. They do what they call a corporate charge-off. And then after they do a corporate charge-off, then they sell the alleged debt to these third-party debt collectors who come after you. And that's why there's only one signature on the paperwork against your property, and that's the signature of the third-party debt collector. And that's why I only add 3 people to the foreclosure lawsuit. You want to add the debt collector, the law firm, and the last servicer. Your goal is to force that attorney to protect that debt collector, because the attorney's not going to want to give them up, because they illegally gave them the loan, because these attorneys are illegally charging people, trying to take people's homes based off of that, and they don't have jurisdiction to do that. The proper venue, Frankie, is in federal court. And if they ever try to kick you out of federal court saying that federal court don't have jurisdiction because of whatever, then at the end of the day, here's the deal. The attorney files these, all of the real estate laws are federal, okay? The real estate laws are federal. The attorney files a lawsuit in state court, and the attorney is a foreign agent. And as a foreign agent, that foreign agent must file in federal court. So that's the simple reason right there to move it out of state court. Yeah, Frankie, it looks like your situation is a little more complicated than what most people call a complicated situation. But you know what? What you're saying here, what they're accusing you of, don't matter in the end. Because see, here's the deal. If you were thrown under the bus, or your dad was thrown under the bus, whoever bought the property in the first place was thrown under the bus and was violated, then anything that happened after that's irrelevant because you were thrown under the bus first at the gate. So anything else that happened after that's irrelevant. That's the way I see it. And Frankie, you also got to keep in mind when you get done bringing the heat that you're going to be bringing and rolling with me, they're not going to be sitting around worrying about who signed what because they're going to be trying to figure out a way to cover their butt. Well, I can't wait for you to file it either, Tony, because that document is the bomb. Now, you guys need to understand that document, that jurisdictional challenge, is what we're using in our online course. And once the online course is launched, it'll no longer be available. But the online course is launched right now, but the document is still available because I don't have anybody that's registered in the course yet. Once someone registers in the course, then that document is going to be taken off of the website, and it's only going to be available to people in the online course. I needed to make sure that my online course for $1,200 has value in it that above and beyond what people are receiving when they invest in a lawsuit package from my website. So that's the way we're doing it. And the actual lawsuit has been upgraded as well. And I haven't had anybody use a lawsuit. I provided the jurisdictional challenge with an affidavit to members that were willing to pay the $200 for it, which was like a sale price, a fire sale, steel sale. And the reason I did that is because I wanted to see how they responded to it so that I can already have what I need to have when I start the course. And basically what they did was they had a hard time answering to it. And so what I did was I followed up with a motion to moot all of the pleadings filed in the case until the attorneys proved jurisdiction. And that motion to moot has been killing them. Now I'm going to wrap this up for now. I'm going to leave my number here. Frankie, if you want to give me a call, I don't know, around 7, I'm going to start the other live stream at 8 o'clock. But you can call me at like around 7 if you like, and then we can talk a little bit to make sure that we get you set up with the best game plan. And then we'll see when we talk if we need to add something else to the plan from one of the other packages to help you get control of the situation that you need to get control of. Here's my number. There you go. There's my number. And if anyone has any questions that's not like immediately important, you can email me at whenincourts1@gmail.com. Okay, Ed, cool. So get your document, Ed, and like I said, review the lawsuit document and the restraining order, and then you can give me a call or text me, and we'll set up a time when we can sit down and talk if you have any questions. And thank you. And I hope I'll see you guys later on this evening when I do the mini workshop where we're going to go over some of the, I need to figure out how to share my screen. So I need to figure that out before that way I can show you guys some stuff. So hopefully I'll see you guys in a few hours. And if you have any more questions, jot them down so you can get them, or just email them to me and I'll cover them. And Ed, you got my number there too. If you need something or if you have any questions, you're welcome to call me. I'll try to remember who you are after you purchase your package. Okay, I'm kidding. I'm kidding. You're welcome, Frankie. And you're welcome, Tony. Thank you for chiming in, Tony, and giving me a little assistance. And I'm very excited to see how long it's going to take you to get your situation control with that new document that I just sent you. So I'm going to get off of here. I got to go cook dinner for my honey, and I will talk to you guys later on tonight. Thank you for tuning in, and I'll see you guys later.